committee. This puts the discussion, this meeting, which is organized by the DJ, in context. On this note, I wish to thank the host of this forum, Professor Aden, the Director General, Nigeria Institute of Advanced Legal Studies, and our friends, panelists, listeners, all over connected to this meeting. The topic has been well introduced by the anchor of this forum, which is to talk about, for me to speak about the mandate of the African Court and the activities of the court. By way of a very brief history, I want to say that the court was created by the Protocol of 10th July 1998, which came into force in January 2004. The African Court was established in January 2006 and became operational in July of the same year, after the swearing in of the first set of judges. It initially started operating at the AU headquarters in Addis Ababa, Ethiopia, before moving to his seat in September 2007. The protocol establishing the court mandate gives it the mandate to interpret and apply the African Charter on Human and People's Rights. Also, the establishment protocol and any other relevant human rights instruments ratified by state parties concerned. For the court to effectively discharge its mandate, the protocol clothes it with two forms of jurisdiction: the contentious jurisdiction as well as the advisory jurisdiction. Contentious jurisdiction. Article 3.1 of the protocol, that is the establishment protocol, reads, the jurisdiction of the court shall extend to all cases and disputes submitted to it concerning the interpretation and application of the Charter. The protocol, that is the establishment protocol, and any other relevant human rights instruments ratified by the states concerned. This arm of jurisdiction, the court also mandate to promote amicable settlements of cases pending before it. You find that in the advisory jurisdiction of the court is provided under Article 4 of the protocol, which says that at the request of a member state of the African Union itself, any of the organs of the Union, or any African organization recognized by the Union, a request can be made for a legal opinion on any legal matter relating to the Charter or any other relevant human rights instruments, provided the subject matter of the opinion is not related to the matter being examined by the Banjul Commission. The court has evolved and developed its jurisprudence on a number of human rights issues. The number of applications before the court is steadily increasing. Substantive judgments and decisions on a range of human rights issues, such as the right to life, access to justice, fair trial rights, right to freedom of opinion, freedom of expression, freedom of association, freedom to participate in one's national government directly or through representation, provision of aid, etc. The court also has a robust jurisprudence in the area of reparation and compensation for victims of human rights violation. I'll speak to that later, and other civil and political rights. Indeed, in all humility, I would say we are setting human rights standard for the whole continent. Access to the court. Who can file cases before the court? Article 5 of gives direct and indirect access to certain persons. Number one being the Commission, State, Africa intergovernmental organizations, relevant non-governmental organizations, that is NGOs, with observer status before the Commission, and individuals can also institute cases directly before the court. Only, and I say only, if the state party against which they complain has made a very special declaration we call the Article 34.6 declaration. I'll throw that now. Limitation in terms of access to courts by individuals and NGO. The protocol requires under Article 34.6 to be read together with Article 5.3 that only individuals and NGOs whose states have declaration can access the court. Consequently, when individuals not so qualified approaches the court has to systematically, but not without a sense of frustration, because of lack of conviction, dismisses such applications. Beyond such individual cases, the African system of which the court is an embodiment seems to have been built upon a fundamental paradox. Whereas the court by definition is a human rights court, and whereas human rights are by definition the rights of individuals, the latter are excluded from the judicial protection system intended for them, for as long as the state concerned has not deposited the requisite declaration. It is said to be a case of a cup half full and half empty. What has done in figures? Total application received so far, 274. Applications by individuals, 274 is 258. NGO, 12. Applications by the African Commission, 3. Applications transferred to the African Commission. We have this complementarity with the African Commission. 4. Number of contentious applications finalized, 90. Pending applications, 197. Number of orders for provisional measures, 43. Rulings on jurisdiction, 14. Rulings on admissibility, 19. Third-party intervention, 1. Judgment in default, 1. Amicable settlement, 2 attempted. Discontinuance, 1. Judgment on merits, 27. The jurisprudence of the court. The jurisdiction of the court is examined in 4 dimensions. We have the personal jurisdiction, material, temporal, and territorial. The personal jurisdiction. The question the court will have to satisfy herself is the applicant a proper person before the court? Vis-a-vis Article 5, which I had referred to, before who and who can approach the court. The court has established jurisdiction in this respect. The court will strike an application filed against a state which has not ratified the protocol. The court has ruled that it manifestly lacks jurisdiction in such cases. We have a lot of decided cases in that regard, but permit me to refer to application 008-2011, Ecolia Moadi Alexandra versus on non-deposition of the declaration. The court will strike out an application from an individual or NGO against a state that has ratified the protocol but has not made the declaration, allowing individuals and NGOs to bring cases directly to the court. We have the case of versus the Republic of Senegal. On application by NGO, as I said earlier, is only acceptable when they have observer status with the African Commission. So the court has over time ruled that NGOs that do not have observer status cannot bring applications for it. And when they do, such applications are struck out. We have, for example, the case of the Association of African Lawyers for Good Governance, that was Côte d'Ivoire. That was the fate of that case. Non-state entity. The court will strike out a case brought against a non-state entity. We have in regard the application 001/2011, Femi Falana versus the African Union. Also, a similar case, Atabon versus the African Union. And another one, Femi Falana versus the African Commission on Human and People's Rights. Material jurisdiction. Here, the subject matter of an application, the material jurisdiction here will mean that it will be in certain instances where the case or dispute submitted does not relate to the interpretation of the charter, the protocol, or any other relevant human rights instrument. The court will strike it out. Where the subject matter of an application is, for example, on breach of employment contracts, the court has ruled that it lacks jurisdiction. Where the application from a domestic court, the court has ruled that it does not have any appellate jurisdiction to receive and consider appeals in respect of cases already decided upon by domestic and regional and similar courts. We have the case of Francis Mitugui versus the court of Malawi in that sense. Where the applicant has cited only provisions of the Universal Declaration, the court has ruled that the Universal Declaration on Human Rights, although not a treaty ratified by states, has attained the status of customary international law and is therefore a grand norm. The court will not insist on a formal indication in an application of for specific mention of a treaty that has to do with the violation. Even if it's indicated informally, the court will identify the violation and consider such application. Temporal jurisdiction. This refers to the jurisdiction of the court over a proposed action in relation to the time the action took place. The court has the jurisdiction rationale temporary is determined from when the African Charter came into force for the state, and not necessarily when the protocol was adopted or the declaration made, because the rights alleged to have been violated are guaranteed in the Charter. In this regard, we have the case of Tanganyika Law System versus Tanzania, where it is continuing because we say it has jurisdiction. We have the case of Robert Zongo versus Burkina Faso in that regard. The court does not have jurisdiction temporal for instantaneous action like murder, assassination relating to the right to life. On territorial jurisdiction, the court will want to know if the alleged violation occurred within the territory of the respondent state. The court will not proceed to admit to consider the validity of a matter if it has determined that it lacks jurisdiction. The case ends there. Where the court is satisfied that it has jurisdiction on the four grounds, material, personal, material, territorial, and temporal, it will then proceed to conduct the admissibility test. Admissibility. Relevant provisions governing the admissibility of applications before the court are Article 56 of the Charter and Rules 40 of the Rules of Court. They provide for the following 7 admissibility requirements. 1, the application must indicate the identity of the author, even where the author requests for anonymity, but the court is entitled to know who. In case we can give the application a number without a name, or any name that does not really is not traceable to the author, but known to the court. The application must, secondly, the application must be compatible and in compliance, must comply with the Constitutive Act, that is the African Charter. The application must not be written in insulting or disparaging language. The application must not be based exclusively on news disseminated by the media. The application must be submitted after exhausting local remedies, unless the remedies are unduly prolonged. The application must be filed within a reasonable time after exhaustion of local remedies or from the date the court is seized the matter. And lastly, the application must not have been settled by another international tribunal. Once the court finds that an application inadmissible on any of the ground, the seven ground, the court need not examine any other admissibility requirements. The reason that the admissibility conditions are cumulative in nature. Exhaustion. I would like to talk a little about the exhaustion of local remedies and the issue of reasonableness before the court, because those are the areas that always come up for deliberation. Application must be submitted after exhausting local remedies, unless the remedies are unduly prolonged. What is the jurisprudence of the court in this regard? The court has held that the remedies envisaged under Article 56(5) are primarily judicial remedies, as they are the ones that meet the criteria of availability, effectiveness, and sufficiency, and they are the most effective means of redressing human rights violations. It is discretionary and not accessible to all, such as parliamentary process, because we have some applicants, they will say they've gone to the National Assembly and all that. Parliamentary process is not an available remedy. The court held that the parliamentary process is not an available, effective, and sufficient remedy because it is not really accessible to each and every individual. It is discretionary and may be abandoned at any time. Moreover, the outcome thereof depends on the will of the majority. No matter how democratic the parliamentary process will be, it cannot be equated to independent judicial process for the vindication of the rights under the Charter. The remedy may be available but not effective, but it may be available, effective, but unduly prolonged. We have in that regard the case of Loyi Issa Konete. The timeline of 5 days to file notice of appeal may not be viewed by the court as unreasonable to be an obstacle for an applicant to appeal and make a remedy unavailable. Where the high hand has not been seized of a matter, the court may consider that local remedies have not been exhausted. Exhaustion of local remedies is not by choice, but a legal requirement in international law, so the court has held. Case of Peter Joseph Chacha versus the Republic of Tanzania. The unduly procedure envisaged under Article 56(5) relates to local remedies in its entirety as utilized or likely to be utilized by those concerned. That was established in the Zongo case. Other requirement of admissibility requirement that always generates a lot of debate is the reasonableness test. Article 56 of the Charter provides the application must be filed within a reasonable time after the exhaustion of local remedies. The court has, where the court determines that local remedies have not been exhausted, it will not even proceed to consider whether or not the application was filed within a reasonable time after the exhaustion of local remedies. We have the case of Chacha in that regard. Where there is no fixed period for exhaustion of local remedies within which to seize the court. Each case will be decided according to its own circumstances. Because of time, I will now quickly proceed to consider our case law on merits. So the court has rendered 27 judgments.
Honorable Judge, you will have next 2-3 minutes to round up.
Okay. Okay, thank you. Today, the court has rendered 27 judgments on merits, where it found violations of human rights and made important jurisprudence in this regard. This includes the right to participate in government, the issue of independent candidates, freedom of association, non-discrimination and equal protection of principle of the rule of law, freedom of expression and protection of journalists, right to have one's cause heard, obligation to protect rights, equality before the law, equal protection of the law.
What
happens when a right has been set, where the court is satisfied that there's been a violation of rights? We have recourse to what we call reparation or compensation. The court is empowered to appropriate orders to remedy violation under Article 27(1) of the protocol and Rule 63. When the court finds the respondent state in violation of any right under the African Charter or other relevant human rights instruments, it may order a remedy including payment of fair compensation or reparation. An adequate and effective reparation may include one or a combination of the following 5 internationally recognized forms of reparation. We have restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. Since we are talking about the activities of the court, we also have non-judicial activities. We have the advocacy and sensitization program. We have the legal aid scheme. We organize national and sub-regional seminars and even continent-wide conferences to which we invite all relevant human rights stakeholders, like the one mentioned earlier by the DG. In conclusion, remain committed to the delivery of justice at the highest quality possible, emanating from the system itself, which provides that the judgment of the court shall be final and not subject to appeal. This places the court most weight as it is, in theory, prohibited from committing the least error in the interpretation of the Charter and its application and other relevant human rights instruments. Moreover, the delivery of quality justice is the guarantees the court's credibility and indeed its long-term legitimacy. It helps in boosting possible confidence among its potential users, including states. The court is conscious of this and is deploying every effort in this direction. Of recent, the court had cause to revise its rules of courts, having identified some lacuna and gray areas. On this note, I once again want to thank the DG for this opportunity and our esteemed panelists, contributors, and listeners all over the world. God bless you all.
Your mic, DG. Your mic is off. Your mic is off, DG.
Hello, can you hear me now? Can you hear me now?
Yes, we can.
Yes, thank you, Honorable Lady Judge Stella Alukan, for your beautiful presentation, very educative. And we'll now give the floor to our distinguished panelists to discuss the presentation in the order advertised. On the list, we have Barrister Yusuf Damadami from the ECOWAS Court of Justice. Yusuf, you have the floor, 3 to 5 minutes in your own style. Take the floor, please.
Thank you very much, Professor Ladan. May I also join my voice in congratulating Lady Justice Stella Onakam for a beautiful presentation. It was very educative and very enlightening. And I think viewers will have benefited from the richness of the quality of our presentation. Let me go straight since I have 5 minutes. First of all, I will just want to say that decisions of the African Court on Human and People's Rights is simply reminding the governments of member states of their and their of the recognition
to me
of their policies in terms of the protections, enjoyment, and enforcement of fundamental human rights, and particularly against vulnerable persons.
Yes, okay, conclude and just bring it. I will send to the
against abuse and exploitations. Let me put it very clearly that, if we have to have any impactful continental or regional development, particularly in terms of economic integration and what we have at the continental level and regional level in Africa, then we must have institutions that will guarantee that individuals develop their potentials without limitations and, of course, without obstacles. And such institutions include the African Court and the Court of Justice. And such individuals must have certain access to a varial court such as this. So on this note, I would like to say that because some of the things that are needed to be done and the issue. But let's conclude by stating my lord, these campaigns actually want you African countries that was a position.
Can they do that tomorrow? Can Professor Morogi stop talking?
Can I continue?
Can Morogi mute his mic?
Oh, I didn't mute it. It's
yeah,
on.
You should mute it. You are talking now. We're not hearing that, madam.
Okay, sorry.
Yeah. So
should actually mute himself or herself, please. Yes, go ahead, Yusuf.
Yeah, then I would like to just conclude, given the limitation of my time. I heard in the presentation of my lord, she said that she was saying that there must be exertion of local remedy. And very different perspective when it comes to food and enforcement and protection of human rights. I think it's not asking I wanted to ask. This is very good that sometimes also I want to amended I think it's only the system or any country to amend that in line with the expression of local remedy, particularly with what we have, you know, in our outside I would like to say, it's very important that I would also want to suggest we have not made a different that at the central level. What we also be looking at is that we also have some and actually have many of my family curriculum, the junior curriculum where all regional courses dealing with human rights, that all evaluate the status of human rights compliance. This is one thing I would like to work on. And lastly, before I go, I know that the relationship we have a practice where we have and this is provided in the rule. And you can call both one to another member of the full citizen. So I would like to also know whether or not actually look in that regard. I like all I want to congratulate the excellent presentation of my work for a brilliant presentation. Thank you very much.
Thank you, Barrister Yusuf from the Edmonds Court of Justice, Abuja. Our next discussant, 5 minutes as advertised. Next Professor Edoba, if you are ready. Professor Edoba, unmute yourself.
Hello?
Yes.
Yes. Well, first let me join colleagues to congratulate you, DG, for this idea. It's quite commendable. This era of COVID-19, we see as the opportunity of engaging in this manner. Of course, we cannot take away the fact that if we are meeting physically, the discussion will be a lot more robust about the challenges of technology, the issue of technology. Nonetheless, we are listening carefully to the presenter.
And we see your face,
comments are. How about me? I've been hard.
Yeah, we want to see your face. Your camera is not on.
Oh, okay. Okay, so how about me see now? How about visible?
We are here to see your face. Did you click the webcam?
Yes, you can see your face now.
Okay, fine. Go ahead.
How about visible?
Yes.
Okay, so I was just remarking that I've listened to the presenter or the presentation, and I think that it's just a basic review of the general vision of the African Human People's Rights Court. But I have a lot of concerns, and the main concern I have is the extent to which the court can give impact, having regard to all the limitations that the has already identified. One of those, to the onset, that when we are talking of human rights has nothing to do per se with state bodies, but with individuals. So perhaps the main problem really is the issue of standing. Who presents or who can appear before the court? That's a matter that we need to review very, very critically, because for me, some cases have reviewed to appear that municipally, it will appear that individual states of the African Union have made some progress, more than even the court protocol has been able to accommodate. For instance, in the case of Nigeria, under the Human Rights Enforcement rules here, you can see that even NGOs can approach court to seek redress. So I find it difficult really to see how the court can truly provide for proper enforcement. I recognize, of course, that challenges of sovereignty regulations are obvious, but when we are dealing with human rights, issue of sovereignty really, as you can see, it's something that must be able to take the backseat. Because we have noticed that even when you are talking of very serious violation of rights internationally, even those who have argued that they were acting based on instructions, state instructions, and so on, the arguments have not sustained. Remember the Nuremberg registrar. So somehow I believe that going forward, there ought to be a way by which protocol or establishing itself can find a way of accommodating individual complaints or complaints by NGOs, so as to be able to broaden the reach of the court. That's why the first concern. Secondly, delay implementing the Banjul protocol. Of course, although the presenter did not engage this implementation, but I'm aware that the Banjul protocol is one that has been trying to include some internal discussion into the entire human rights regime on the African court. So I think that state actors have to be able to find a way to see how we can accelerate the commencement of the court, so as to be able to accommodate some of the major concerns about crime committed, which have, of course, crime committed that can be interpreted as violation of human rights. Particularly, if you look at the entire Central African Republic, you have a lot of Central African nations. You have simmering internal armed conflict there. Those areas, those regions. Currently, there's no result. As to except you have to go outside of Africa, to be able to redress against these sort of violations.
Professor Doba, you have
Yes.
30 seconds.
I hope I've not exceeded my time.
You have 30 seconds left.
Okay, so I'll stop here at the moment. I'll allow that to contribute.
All right, thank you very much, Prof. Thank you, Professor Doba. Next discussant, Barrister Hawa Ibrahim from Federal Ministry of Justice. You have the floor.
Thank you very much, Prof. And I join all those to congratulate you and to appreciate the Honorable Doctor for her presentation. I actually particularly like the fact that she took time to explain the concept of a version of local remedies, which initially because we found that people are not really aware of the functions of the court. Some are not even aware of the nature of the court because they keep confusing the court with the Court of Justice and Human Rights, which actually includes the Malabo Protocol, which was created by the Malabo Protocol and is only on paper. So the attention of local media as the family factors and the before the court is actually one of the aspects of the protocol that needs to be widely disseminated, especially among state countries. Because I suspect the states are not, there's this fear of the unknown. They don't know to what extent and whether the import of Article 34 subsidies will systematically do away with the requirement for relation of the domestic revenue. And then, like I said, not understanding the nature of the court itself, some of them are thinking it is actually the African Court of Justice and Human Rights, which has the extended jurisdiction in international crime. So I like that. And then I would like to Article 5 from her presentation. It's surprising that the African Commission, of which the court is supposed to complement, is actually not referring cases to the court. I mean, with the way things are going, state parties are not depositing directly with the declaration to trigger to activate the mandate of the court over them. So, and from the recent exit we've seen, even the host, Tanzania left, it's actually some scandalous actually. So I'm thinking the court should strengthen its synergy with the commission. Yeah, there has to be. I'm surprised there are only 3 referrals from commission. That is actually not good for the work the court is doing. And most of the cases, more than 90% of the 274 cases the court has actually treated was actually through this window from the NGOs and direct individuals, directly from NGOs and individuals. Now, I don't see a future in that for now. I'm sorry. While the court is actually engaging state parties and the African Union to get them to support the court through by making through their commitments when they ratify. Now, even the ratification, you have like only 30 countries have ratified the protocol. 1998 protocol out of 53 states. That's how, so I think the most immediate feature I see for the court is for enhanced engagement with the commission. I mean, otherwise, I don't know what will happen to the future of that court. I would rest here because I have so much going on in my head, and I see the time is almost gone. Thank you.
Okay, Hawa Ibrahim from Federal Ministry of Justice, Abuja, thank you very much. Next discussant has 3 to 5 minutes. Dr. Osato, are you on the line?
Yes, I am. Good afternoon, DG.
Yes, good afternoon.
Yes, I would like to align myself with the other discussion as regards thanking you for this opportunity for us to have a robust discussion online. I would like to thank the presenter also for her presentation on the mandates of the African Court. For me, basically, I think it is worrisome with regards to the ability of direct access to the Human Rights Court. As Professor Edoba Amorege rightly said, the issue of human rights concerns of state and the fact that first of all, from the provisions you find that in Article 5 you have access through the state or through an NGO if the state has signed declaration, Article 34 declaration, Article 34 declaration. So we find a situation where, in most cases, we know that in Africa, the violation of human rights actually has the state itself. So if the state has to actually provide a declaration, or if individuals have to actually assess their rights or go through very sure that why there is a low acceptance or ratification of Article 4.6 declaration. 2020, have just have acceded where I didn't hear from the Africa how maybe African Court of Justice for Human Rights will eventually create work of the court. I think that's somewhere that Shimon would like to explore more in her paper. And from what I've read and gathered so far, I think where the court is now and where it's going to be people when they do definitely failure of court of justice court of human rights, then there's there's actually going to be some opportunity for changes that will help the mandate of the president. I think I would like to talk.
All right. Thank you, Dr. Osato. Please, whoever is not taking the floor should actually, mute himself or herself so that we can only hear one person talking at a time. Okay, Professor Edoba, please off your system. All right. Our next discussant on the line. Next. Yes. Next discussant, 3 to 5 minutes.
All right, DG, sir. Yes, can you hear me, sir?
Yes.
Okay, all right. I want to first of all thank the presenter, my lord.
Your name?
My name is Lilian Uche from Nigerian Institute of Advanced Legal Studies. So let me thank the presenter. She has done a good job by broadening our knowledge on the activities of the African Court. So, but I have always had my reservations with the court in terms of the areas of enforcement and compliance with their judgments. So what I don't know is, for instance, to what extent, from her knowledge, from the little time she has spent as a judge, like to what extent do the state authorities implement the orders of the court? Secondly, I also know that the protocol established in the court mandates the court to publish an activity report, more like the report of the activities, No, I think refer to under section Article 21 and 31 and 29, So, but beyond this information published by the court in this activity report, there is really no one place where one can go and find what the state has done to respond to the judgment and all that. So, in terms of reparations as well, can she tell us maybe clearly whether their judgments are being actually respected by state parties and others? Thank you very much, DG.
Lillian Uche, thank you for the intervention. Any other discussants are on the list as advertised? Any other discussant? All right. The floor is now opened. I can see we have some distinguished judges that join us across the globe, 2, 3, 4 from even the African Court, and then I also saw the Registrar of the African Human Rights Court also join us, Mr. Eno, Dr. Eno, please. So the floor is now open. I can see Dr. Bello Fadile has been very much around. I can see Mr. Feyi Oguntade has also been very much around. Professor Timothy Yarima has also been very much around. So the floor is open for only 1 to 2 minutes intervention for non-discussant. Yes. Yes, Professor Dr. Bello Fadile, you have 1 minute.
Okay, thank you very much, DG, and congratulations, my lord. I'm Dr. Bello Fadile, a research fellow at the American Heritage University of Southern California. Just 2 quick points I want to make. That from what we have, only 9 states have filed a declaration allowing NGOs and individuals to approach the court. Nigeria is not one of them. Is that not strange? And then secondly, what is the relationship between the Commission, the African Commission, which is a quasi-juris body, and the influence it has on the court? I find it very, very disturbing that you have a human rights court and you have a commission kind of supervising or reconciling with them, complementarity they call it. So without human rights, we have a problem of security, we have a problem of economy. So I think we need to talk about this and see how we can move forward and let Nigeria file this declaration to allow NGOs and individuals. Thank you very much, Prof.
Thank you.
DJ, good afternoon, sir.
DJ,
good afternoon, sir.
Yes, the Jack Colonel and also former director and also of the NSA. I'm exposing him. Okay. Professor,
DJ, good afternoon, sir.
Professor Timothy Yarima.
DJ, good afternoon, sir.
Thank you.
Yes.
Thank you, the DJ. Let me stand on the existing protocol, and but let me also comment the presenter and all the discussants.
Who are you?
I'm Professor Timothy F. Yarima, Professor of Law, Faculty of Law, Kogi State University. I'm particularly concerned, and that is what actually was omitted or is omitted in the presentation, the issue of complementarity, which is very, very important. We have to recollect the fact that unlike the European system, under the African human rights system, this court was established to complement the protective mandate of the African Commission. So the African Commission and the court have to work hand in hand. And as somebody asked, if you peruse the cases decided and pending before the court today, we have the 272 cases have been received by this court. Only 90 have been finalized. 195 cases are still pending. Only 4 cases have been referred to the commission by the court. That is to say that till date, this court has not realized the imperative role of the African Commission on Human and People's Rights. It is not to substitute the commission, but to work hand in hand with the commission. And the commission itself has only filed 3 cases before the African Court on Human and People's Rights. So I begin to ask this question: what is actually wrong? It means these 2 bodies have not actually seen their relevance. They have not actually exhausted the complementarity relationship that has been established by the protocol itself. That is one aspect. The second aspect is the issue of compromising individuals and NGOs' direct access to the court. It is actually a concern. But let us ask this question: if today individuals and NGOs are given direct access to access this court, how many cases will be pending before African Court on Human and People's Rights? In which case, has the court effectively discharging the cases before it? As I pointed out, we have 2 out of the 272 cases. Only 90 have been finalized. 195 cases are still pending. So you cannot imagine what will happen if individuals and NGOs are to have direct access to this court. So I can say that the African human rights system should look into the structural deficiencies of the court, including the statutes and composition of the court. As it is today, the court is composed of only 11 judges, and only the president of the court was on full-time. The rest was on part-time basis. And there's no way the court will be effective enough to be discharging the cases before it. And again, the court has been taking, if you look at the various reports, the activity reports of the court has been taking its time to go on sensitization, or what we call awareness program, to various states. So I ask this question: is that not supposed to be the work of the African Commission on Human and People's Rights, which is the court is protecting, the court is complementing the protective mandate? And if you look at the mandate of the African Commission on Human and People's Rights, the first one is the promotional mandate, and the promotional mandate is the educational mandate of the commission. Why can't the court leave this area of sensitization to the African Commission on Human and People's Rights and concentrate on discharging the cases before it? One of the discussions, I think the second discussion. Thank you very much. Thank you very much. Thank you very much. Thank you very much. Can I make an intervention?
You have the floor. 1 minute.
Thank you very much. And I wish, can you hear me?
Yes, we can hear you. Introduce yourself.
My name is Dr. Feyo Gwade. And yes, I used to be a senior legal officer for the African Commission. And I worked very closely with Dr. Eno. As a matter of fact, I worked under Dr. Eno for some time before I left the African Commission. I needed to congratulate the discussant.
So where are you now? Are you in diaspora?
Yes, I am speaking to you from London. I'm speaking to you from London. Yes. And there are 2 issues I just wanted to bring up very, very quickly, and that's the relationship between the African Commission and the African Court.
it's a very dicey relationship. And one of the things which has troubled me, particularly when you look at the Inter-American system, the Inter-American Commission supplies a lot of cases to the court. As a matter of fact, when you compare the two, I think the Inter-American Court gets about 30 cases from the Commission. And sometimes I wonder, what is stopping us at the African Commission from giving a lot of cases to the court? Because the truth of the matter is that a lot of the state parties are reluctant to give cases to bring cases to the court. I mean, no state party has brought another state party to the court. And when you look at 34.6, a lot of the states are regressing from their obligation to the African Commission to give cases to the court. And that is a worry. And I suspect it is not only political, but I suspect it is a problem of the person who is at the commission. Unfortunately now, we have a change of guard at the commission. So I am hoping that the conduit will be open so that the court can receive a lot more cases. Now, in terms of understanding the African human rights system, particularly the function of the African Court and the African Commission, my worry about the court, I know the last speaker exemplified my worries that the court should really not be engaged in promotion. But because promotion has been lacking all around the continent, particularly with state parties, and because the African Commission has not discharged its functions of only promoting the African human rights system, so the court is forced to introduce itself to the African peoples. My worry is, I think the court is trying, absolutely trying, and people like myself are watchers of the African human rights system very, very closely. And the court has done, in my view, a sterling job, absolutely brilliant job in trying to introduce itself to the African people, but it is not enough. And I will put it to the panelists and even to Dr. Eno. I hope Dr. Eno is listening. If I was at the courts as the promotion officer, one of the things I will introduce immediately is a radio program, an online radio program. And I simply do not understand why the African Union, and when I was at the commission, why the African Union has simply not introduced, say, an online TV and to just streamline all the activities of the court and the African Commission. As a matter of fact, I'm now running a new organization called AU Watch, where we are trying to hold both the African Union and the African Union member states accountable to the standards they have set for themselves. And one of the principal goals we are doing right now is to have a radio station and a television station so that the African peoples can be more involved in what we are doing. So I suggest
all right, Mr. Faye, you have just said your time for the intervention.
I'm here.
For joining us from London. And you will have another opportunity as we actually proceed. I can see there are quite a number of people that are joining us. Some of them. I'm here. I can see the president of the court is on the screen. I would like to specifically thank him because I met him in Kampala, Uganda last year during the conference, and I would like to give him the opportunity, 2-3 minutes to intervene. We've been having very fruitful discussions. Honorable, Your Excellency, you have the floor. Yes, you have the floor.
Thank you very much. Thank you very much, moderator. I would like to thank the organizers of this meeting for the opportunity to talk about the report.
Good afternoon, sir.
Yes.
Yeah, the discussion.
Good afternoon.
Questions raised.
Please hold on. Somebody's on the floor.
Yeah.
Yes.
So
yeah, Your Excellency. Your Excellency, can you introduce yourself?
Okay. Oh, okay. I thought that you already introduced myself.
Yeah, we want to hear it from you also.
Okay. Sylvain Ore, the president of the African Court, and the colleague of the Speaker of Justice. So
you can go ahead.
I was saying that.
Don't go.
Okay, so I was saying that,
I'm giving you
as I
back.
heard, and the discussion and the questions raised, it proves that there is a real interest on the work of the court, but also that we have among you some experts who knows the issue that the court face now, particularly the last speaker about the relation with between the court and the commission, but also the implementation of the decisions, and also many steps that we have to go along to improve the mandate. We appreciate the intervention of Justice Anukam, and we encourage such kind of initiative. So I would like to thank the participants, and I would like also to congratulate the moderator for the good moderation that we is doing now. As you can see, I'm here with our colleague Justice Imani Aboud, also Judge Kenya, and also, as you mentioned, Dr. Eno. And we fully support our colleague Justice Anukam. Thank you very much.
Thank you, Your Excellency, the President of the
Moderator,
Court on Human Rights. We are very grateful for finding time to join us and to support our Honorable Lady Judge Stella Anukam for our presentation. We would like actually to open the floor for 3-4 more interventions in 1 minute. Yes, another person who wants to take the floor, please.
Yes, DG, I'll be here since 12.
Okay, Professor Paul Idoniji, you have the floor. 1 minute.
Thank you very much. Let me quickly say welcome to Lady Justice Stella Anukam to NIAS, and to say that the issue of Article 34.6 declaration has been.
Prof, we are having participants from all over the world, so they don't know what NIAS is. Spell it out in full.
Oh, okay. So the Nigerian Institute of Advanced Legal Studies. Thank you very much. And to say that Article 34.6 declaration cannot be sufficiently addressed. It's a matter of concern to many of us. But I think for today, it has been addressed. Let me move to another issue. That is the merger of this court with the African Court of Justice. This has been on since 2004. Then we had a protocol in 2008. I would like to know, where are we on this issue of merger of these two courts? Thank you very much, DG.
Right, thank you, Professor Paul Idoniji, SAN. Another person that wants to take the floor?
Yes, DG Francisca.
DJ.
Yes, actually, Professor Francisca Leru, you have the floor. 1 minute.
DG, good afternoon, sir. My reaction is on the administrativity requirement of the court. I was looking at the issue of exhaustion of local remedies and, of course, the avoidance of inordinate delays, which is the reason why, I mean, when you exhaust local remedies, you can come, and you have to, when there's inordinate delay, you can come to the court. Looking at the issue of inordinate delay and the fact that the court has series of pending cases and that the court also sits 4 times a year, I am asking, will the applicants not face the same issue of delay when they come to the African court? Because it appears that there will be delay, there will be no quick dispensation of justice. Because if a court sits 4 times a year and for 15 days in any of the sittings, it will not have enough time to discuss all the issues. So the applicants will still meet with the same inordinate delay. So I expect that the court will look at this and maybe fine-tune the operations, because the same thing the claimants are running away from, they will come and meet at the African court. My little intervention, sir. Thank you, sir.
Thank you, Professor Francisca Leru.
Yeah.
Another person that was to take the floor.
Moderator. Yes, moderator.
Yes.
Moderator.
Yes. Yes, go ahead.
The registrar from the court.
No, he's asking the floor.
Honorable Registrar, please take the floor and introduce yourself.
Yes, Prof.
Yeah,
yes, Prof. My name is Robert Eno, the registrar of the African Court. I would like to thank Justice Anukam, and I want to recognize my president and Justice Aboud, and my good friend Dr. Ogunade, and to thank all the panelists for the interest shown in the work of the court. I also want to crave your indulgence, moderator, to give me a little bit of time so that I can address some of the issues that have been raised. And maybe some of the judges may want to also contribute to that.
Okay, permission granted.
On the issue raised,
1 to 3 minutes.
Thank you, sir. On the issue raised by the last speaker about inordinate delay, it is something that the court has taken into account, and we are working very hard to improve on our working methods. Currently, the average time for the disposal of cases before the court is about 36 months. We are changing our working methods. We have introduced an electronic case management system, and we are hoping that we can reduce that average from 36 months to about 24 months within a period of 2 years. We take cognizance of the fact that there are some cases that may have been before the national courts for, say, 10 years, and they come again before the African Human Rights Court and spend 4 or 5 years. So that is very, very frustrating for some of the applicants. So we are taking measures to see how to reduce the time for the disposal of cases before the court. On the merger between the African courts and to establish the African Court of Justice, just to indicate that the protocol, the Malabo Protocol, was signed in 2014 for the merger, but up to now, there has been, I think, 12 signatories, but no ratification at all. So this issue is not within the purview of the court. This is an issue of member states not wanting to ratify the protocol. So the court has no control over this particular issue. But just to say that for the moment, there is no ratification at all. And we need 15 ratifications for the protocol to come into force. So until that happens, the African Court on Human and People's Rights remain the only judicial organ of the African Union. I like the intervention of FEI. Of course, FEI worked with the Commission for a while, and we've been working for some time now. But just to indicate that the comparison between the African Court and the Inter-American Court, there is a little nuance, because at the Inter-American level, it is only the Inter-American Commission that can bring cases to the Inter-American Court. So the Inter-American Commission will first of all exhaust all possibilities of solving a case amicably. If it fails, it then takes the matter to the Inter-American Court. The problem we have with the African human rights system is that both the African Court and the African Commission have been endowed with protective mandates, and each of them want to conserve that protective mandate. The African Commission can refer.
Very good, huh? There are some things I just.
Sorry, Chair, there's a noise in the background.
Professor Edoba, please.
Mandated to set cases before the African Court, but it is not obliged to do so. So it is not surprising, therefore.
So that's why I
I can't to be the noise. Okay, thank you. On the issue of the court engaging in promotional activities, let me indicate that I joined the court in 2010. The court became operational in 2006. Between 2006 and 2010, the court had received only one case. And I understand that there was a huge debate within the court amongst the judges themselves, whether they should engage in promoting or encouraging states to ratify the protocol and make a declaration. But because the court realized that for 4 years they had received only one case, there was no point going to Arusha every now and then to sit and then deliberate over nothing. The court then decided to take it upon itself to limit its promotion only to the issue of ratification and making of the declaration with respect to the court protocol. The court does not do promotional mandate in the classical sense as the African Commission. The court's sensitization visit is limited only to encouraging states that have not done so to ratify the protocol and make the declaration. And I can assure you that from 2010, when the court started, to now, the number of cases have increased from 1 to 274. So it means that the promotion, the sensitization visits are working. And the visibility of the court has also increased tremendously. So, and I should also add that the court does not intend to continue this exercise forever. We are developing a system in which we'll gradually cede this particular exercise to civil society and other stakeholders that can do this. We are now currently working with the Office of the Legal Counsel, working with the Pan-African Parliament and other stakeholders that can properly continue with the sensitization process, not only of the court protocol, but of other instruments of the African Union. In any case, the court has sufficient cases now to occupy it, that it can adequately or conveniently relinquish the issue of sensitization and concentrate on judicial matters. Chair, with your permission, maybe two other points. There was a question about enforcement of the decision of the court. Just to indicate that the court has delivered more than 30 cases on the merits, on reparations, and issued about 27 orders for provisional measures. I'm disappointed to note and to report that of all the judgments delivered on the merits, only Burkina Faso has fully complied with the judgment of the court. There are few countries that have complied partially. There are some countries that have expressly told the court that they are not going to comply. So the compliance with the court judgment is becoming one of the most serious challenges in the effectiveness of the court in particular, and the African human rights system as a whole. And in view of that, the court has developed a compliance monitoring framework, which we have submitted to the African Union, which will enable not only the court, but policy organs, political organs of the African Union to effectively monitor compliance by member states of the judgments and orders of the court. This process is ongoing, but we hope that when this is done, there will be a better compliance with the judgments of the court. Chair, I think maybe I should end here, except if there is some burning issue that you would want us to respond to. But I want to thank you again for organizing this particular meeting. Thank you very much.
Thank you, Registrar. We are very grateful for your kind intervention and in support of your Lady Justice. We would like to assure you that you've actually done justice to most of the 20 issues raised. And I think it's a very good family that we can see. I'm surprised that we invited only one Lady Justice from the court. Surprisingly, with our discussants, the entire court just invaded the program, from the president, the registrar, and some judges. But that is there any other person that wants to take the floor?
Yes, DG.
The floor is open. We have
yes, DG. This is Senator Jerry Mahagwe, Director General Administration from the
you have 1 minute.
Nigerian Institute of Advanced Legal Studies. Yes, I appreciate what the registrar. Has just said with regard to compliance and enforcement. However, my contribution is considering the monitoring framework of the judgment of the court. It's like backing and not biting. So what is the way forward? What really is the way forward?
Another person that wants to take the floor? All right. So let's assume that we've had a very robust discussion, and we've also taken some responses on behalf of
can I just respond?
Okay, please, 1 minute.
To the last speaker?
Yes, 1 minute.
Yes, just to indicate that currently the court is reviewing its rules. I think during our next session we are going to adopt those rules. And in the new rules, the court has made provision for the possibility of the court itself monitoring the implementation of its own judgment. This will be done through the process of what we call compliance hearing, where we can invite the state as well as the applicant to come before the court to indicate the extent to which they have complied with the judgment of the court. This way, the court will be able to monitor and ensure that its judgment or orders have been complied with before making a report to the policy organs. So just to indicate that the court is taking measures towards that. Thank you, sir.
Thank you very much. That is very reassuring. Thank you.
Thank you, Doctor. My worry actually is that if you are moving towards inviting the state party and the applicant, what if the applicant, in the typical African setting, is actually poor, vulnerable, disadvantaged? And how can such an applicant get himself or herself, on the same forum with the state party that violated his or her rights? Who is bearing the cost of bringing them together, particularly the applicant? And at what kind of forum are you envisaging for that kind of bringing them together?
Can I?
Yes, please. Yes, go ahead.
As I said, this is a hearing. It will be a hearing like any ordinary hearing. So it will be a public hearing. The two parties are invited. We require legal entity established within, and if the applicant can prove that they can benefit from that legal aid scheme, I think the court can facilitate the appearance of the applicant before the court for the purpose of that hearing. So the legal aid scheme can be utilized, I think, as well. I speak on the, I stand to be corrected because Justice Anukam is a member of the court's legal aid committee. I think Justice Abud is also one of them, but they may want to speak to that if I'm wrong.
Yeah, no, I think it's the framework that we want to understand. So I think you've answered it rightly. So what is important is that there is a legal aid scheme to support poor or indigent applicants. That's the most important framework that we're looking for. We would like to give Honorable Lady Justice Stella Anukam just 2 minutes, not to respond to every question, just round up in 2 minutes.
Thank you, DG, our host. I just appreciate everyone for brilliant questions asked and the interest also shown in the court. Actually, the African court belongs to all of us, all the citizens of Africa. So it's a thing, or it should be a thing of concern to us how the court is functioning and how it is realizing its mandate. So I'm glad, I'm very happy with the questions that that this discussion has generated. And I think to a large extent, some of them have been addressed, but for a time as short as this, it will not be possible to address them all. But basically, the very important ones, I think, have been addressed. And we can always continue the discussion in any other forum. And I hope we should have more so that we get to know what the challenge of the court is. They need to strengthen the court for the benefit of the citizens of Africa. So on that note, thank all the participants. I want to thank my president. I thank my sister, Justice Abud. I thank the registrar, always ready. And I thank everyone, truly. I'm very excited about this. And I think the outcome is, I see it as a push, as a further challenge on the courts to look into the nitty-gritty of all the issues that have been raised and see how we can forge ahead to be able to deliver on our mandates effectively and efficiently. So on that note, I say thank you to everyone. Thank you, DJ.
Thank you, our lead presenter. It's rather unfortunate we didn't hear from your sister, Honorable Justice Lady Abud. Can we hear her for a minute, if she's still around?
She is.
Okay, please, can we have her on the floor for 1 minute?
I'm around. Thank you, Honorable Moderator. Yeah, I don't have much to say, just to thank my lovely sister Stella for the very well presentation. In fact, he presented the court very well. And also to thank Dr. Eno and my president for their contribution. I think this meeting has generated a lot of encouragement for others, especially the Africans, to know and to make the decision to support the court in any way, because the court needs support from most of Africans, especially you professors and others who can give the support to the court for any advice or anything which will improve the work of the court. Thank you very much.
Thank you, Honorable Justice. Our job at the Nigerian Institute of Advanced Legal Studies is to also promote African institutions within their mandate and activities. And that's why we chose actually to bring Honorable Lady Justice Stella Anukam to give us the first public policy lecture series on the African court system. And we are happy that the entire court, supported us as a family, and the responses from the president to the registrar and to the last speaker, testified to that fact, and we are very grateful. So we'll continue to partner with the court, and we will do our part. We will actually document the proceedings, and then we have about 70 research fellows in the institute out of 310 staff. 70 research fellows. They will continue to research into this area. We'll continue to promote and propagate, and also send some of our feedbacks, in our journal articles back to the court for consideration. Thank you very much. I would like to thank our panelists, Barrister Yusuf Damadami from the ECOWAS Court of Justice, Abuja, Professor Edoba Omoroke, Director from the United Institute of Democratic Studies, Barrister Hawa Ibrahim Kuti from the Federal Ministry of Justice, Dr. Osato, Senior Research Fellow, Journalist Advanced Legal Studies, Barrister Lillian Uche, Research Fellow, Nigerian Advanced Legal Studies, and all those and all those who also participated, from London, and other parts actually of the world. We are very grateful, particularly to His Excellency, the President of the Court, who took time to join us and also to address us for 2-3 minutes. For the Registrar of the Court, we're happy that you provided some responses, and we are very grateful. So we'll continue to actually provide a little support to the African Court and the African Commission in any possible way that we can. Thank you very much. This particular public lecture series #1 is over, and then you can join us for our next second public lecture series, which comes up on June 4th, Thursday next week. It's going to be on compliance, monitoring, and enforcement measures to COVID-19 in Nigeria, challenges and policy recommendations to our government. And that will be delivered by another seasoned professor, and a group of panelists, will do so. So thank you very much. The lecture is over. See you next time. Bye-bye.
Thank you.
Bye-bye.